Hi, Dr. Scott Jensen here. I just wanted to give you an update on the lawsuits, and I want to say thank you again for your generous support, your kind words, and your inspiration. I know there's a lot of prayers going up for my wife and I, and we appreciate it. The first lawsuit was in the State District Court against the Attorney General Keith Ellison's office for not complying with the Minnesota Freedom of Information Act. On that one, the Minnesota Freedom of Information Act is actually under the name of the Data Practices Act. But regardless of the title, I feel that we prevailed in that suit, which is now closed, because the Attorney General submitted some documents to my lawyers and I at our request, but openly indicated that he had more documents that he would not share because he was concerned with what would we do with them in the public square. We might actually have the nerve to discuss them in the public square. We felt that he was not entitled to decide what he would or would not share with me. We wanted everything we were entitled to. The judge got involved. The judge made it clear that she had concerns regarding the Attorney General's office doing this. So in the end, the judge ruled that the Attorney General's office had to submit another 10 documents to us, dozens and dozens of pages, to which we were entitled to review. We received those documents from the Attorney General's office, and they did provide some insight for us in our other lawsuit, which is still ongoing. So I appreciate the fact that the judge ruled that the Attorney General's office did not get to make a unilateral determination as to what they would or would not share with us. The second lawsuit is in the federal district court, and that is a complaint against the Minnesota Board of Medical Practice. So they are the defendant, I am the plaintiff. And in that suit, we're saying that they infringed on my First Amendment rights. Now, in the near future, we're going to be in court on this because we've already had a couple of go-arounds, and Judge Blackwell indicated that he would dismiss the case because we did not have standing. But he also invited us to submit additional information regarding our complaint, which he would consider, such that he would reconsider his decision to dismiss the case. What does that all mean? Well, in court in the near future, my lawyers are going to argue that indeed, by the Minnesota Board of Medical Practice's repeated investigations and allegations, that they harmed me, that the harm that was caused to me was caused by the Minnesota Board of Medical Practice, and that if the court would rule in our favor, they could remedy that harm by making certain that it wouldn't happen again. So that's where we're at. We're asking the court to recognize the standing legally that I have. If I don't have standing, then I don't get to be in court. So we're arguing that in the near future. And honestly, I don't understand how someone could say that I wasn't harmed when I had a total of 6 investigations against me, numbering some 18 to 20 allegations. The governor himself, during our campaign, used the fact that I had a complaint against me during the course of the campaign. He used that to challenge the viewer, the audience. How could Dr. Scott Jensen be a suitable candidate for governor if he's being investigated by the Minnesota Board of Medical Practice? Of course, the governor did not mention that the allegation may have been nothing more than a screenshot of a tweet or the screenshot of a hit piece by the Democratic Party against me. Those things happen all the time during an election campaign. And the fact that that's all it took to generate an investigation by the Minnesota Board of Medical Practice against me rankles me deeply. So that's where that suit is at. Hopefully the judge will recognize our standing and we can get on with the heart of the case, the infringement of my rights to speak freely as a citizen of America. Not for a minute do I deny the Minnesota Board of Medical Practice's jurisdiction over my professional conduct. How is it that I take care of patients? Do I meet the standard of care? Those kinds of, if you will, guardrails is where the Minnesota Board of Medical Practice should operate from. But when we clearly have spurious allegations and complaints against me from people who have never met me, who have never seen me as a provider, who simply heard me give a speech at a rally or on the Senate floor and chose to initiate a claim or allegation against me. Thanks again for engaging. As far as I'm concerned, we are all in the arena, because on this one, if they can do this to me, they can sure do it to you. Dr. Scott Sensener, thank you again.